Hello, everybody. Good afternoon, and thank you for attending today's session on the VAWA forms. We are very, very lucky to have Andrea Miller back to talk to us. She is one of our experts in the community on what VAWA is, and a lot of you have had questions about what's required in your documentation, what forms do you have to have in the files, who fills out what. And Andrea is going to talk you through some of these things today. And it's not so much a slide presentation today as it is a conversation. So I'm going to watch the chat, and if you have questions, you can raise your hand or put something in the chat. I can unmute you if that would be helpful. I'm getting a note that there's a terrible echo. Raise your hand if you're getting an echo. Okay, got several people. Well, I'm going to try to mute myself here and turn it over to Andrea, and maybe that'll turn off some of the echo. So, Andrea, the screen is yours.
All righty. Well, hello, everybody. I can't see your faces, but I'm excited that you were able to join this afternoon while we do a little bit of a more targeted dive into the Violence Against Women Act, particularly the form section of that. I did not, as Laura mentioned, prepare a specific PowerPoint. The conversation that we were attempting to have today didn't really seem to lend itself well to that bit of need. I can send out the PowerPoint from before that has a much deeper dive into the actual VAWA regs and things that we talked about, I think, back in April. And I will go ahead and drop into the chat just the VAWA forms in general, just so you can have those. There's really only three. And let me do that real quick. There's one, there's two. And then just for giggles, there you go. Okay, so what I wanted to share specifically, because that seemed to be some of the questions and what Laura mentioned was, what do you have in your files? What's necessary? Who's required? What's covered? Things like that. So in the former PowerPoint, I provided an entire list of programs that were subject to VAWA. So basically, that's HUD funded programs. And I will go ahead and start naming off some of those just to kind of remind us of what a covered housing program um, means when it comes to the Violence Against Women Act. So public housing, any public housing whatsoever is subject to VAWA. Any tenant-based vouchers or housing choice vouchers or project-based vouchers coming through any kind of Section 8 or Public Housing Authority, all those vouchers are subject to VAWA. Any, I mentioned already, said Section 8 project-based rental assistance. That's another program. Section 8 moderate rehab or single room occupancy projects. Section 202 supportive housing for the elderly. Section 811 supportive housing for persons with disabilities. Section 221 multifamily rental housing. Housing opportunities for persons with AIDS or HOPWA. Home investment, so any of the home programs like Home TBRA, any of that. Anything from the Affordable Housing Trust Funds, the Emergency Solution Grants Program, the Continuum of Care programs, and Rural Housing Stability Assistance programs. There are some others, LIHTC developments, and rural housing developments. So VAWA, that was reauthorized in 2022, had a couple of other lists on there. So it's incredibly comprehensive, the list of programs that are subject to VAWA. And then as a kind of an add-in, for those of you that are operating a COC program and providing tenant-based rental assistance to landlords in your community, big landlords, little landlords, doesn't matter. If they accept the assistance that you are providing through the COC program, they are subject to VAWA. And so, to go back to the what forms would you need? The first form you would need is a VAWA lease addendum. And I did not drop one of those in the box. I can definitely do that. But you should have a VAWA lease addendum with that landlord as part of your rental assistance, your file, your housing file. Um, just a couple of, I guess just a question, if you could couple people respond or everybody, whatever. Do you know what I'm talking about with the VAWA lease addendum? Is everyone who's providing rental assistance using that form? If you're not, you need to start. That one's a pretty easy one. Thank you, Roshni and Eve. I see chats. Okay, Teresa, we can chat separately if you're not using it and you think that you maybe don't have to. Again, if you are providing rental assistance to a family in a unit with a landlord, you must have a VAWA lease addendum. All righty. And then any questions, comments about that in the chat? Looks like everybody is pretty much yesing. Okay. If you're the master lessor, if you were doing like something with PSH or permanent supportive housing, you are also, of course, subject to VAWA, and you should have that VAWA lease addendum in your file. And you will probably also be using what's called a notice of occupancy rights under the Violence Against Women Act. I dropped that form in. It's called the Form 5380. And it actually is a really nicely written as kind of a Q&A. Just it's for providers, but it could also be for survivors to kind of take a look at because it does have some Q&A questions on there. And that form has to be given out by the covered housing provider um, at the time that a person leases up, at the time that they might be denied assistance, at an eviction or termination notice, or at a recert when it's required by the program. So have people seen this notice of occupancy rights? Again, that's the Form 5380. I dropped it in there. It talks about rights for survivors. We see it a lot in some of the programs I mentioned earlier. Like I see it in public housing. I see it with Section 8 leases. I see it with large landlord properties that they are taking federal money. They know they're subject to VAWA, so they already give that out at that time. Is anybody seeing that? Yes. No. Okay. I got Emerson saying yes. I got one yes. Okay. I would encourage you to pull it off of this chat, and I see some more yeses popping in. So that document is actually a really great read if you're looking for some very specific information. It's the same kind of information that we cover in our VAWA trainings. And we can do those for agencies that would like that for staff. If it's we do it for the COC usually once a year, but we would also love to talk to people in the community if you feel like you need a little bit of a specific Q&A under VAWA. So we can do that. You just need to reach out to me. I'll go ahead and drop my email in the chat or I forget. Okay. And then you can reach out to me and we can do some more in-depth VAWA training specifically if that's what you're looking for to talk over specific situations. That's normally where I get a lot of people asking for some technical assistance is here's the story and what options do we have? How can we talk about this with a particular victim? So okay. So we've chatted about the notice of occupancy rights. We've chatted about the VAWA lease addendum. And so if you're a provider, you are subject to those things. And if you're working with landlords, you need the lease addendum for your file. Um, so what happens then if a survivor applies for housing? Your survivor, you know the person is a victim, or maybe you don't at that point, but they apply for a housing unit and then they're denied. And then the person who's denied them gives them the reason why. There's usually a report that they're looking at, housing, like a consumer report of some sort that details why that person was denied for that unit. Sometimes what we find when that happens is we'll check in with the survivor if they've been denied and say, hey, walk us through what happened so that we can make sure we address this, or maybe we can work with this landlord in this particular situation. And many times, what we find in our work is that it was because of a domestic violence incident that is reported in this consumer report as potentially an eviction, or maybe it's a poor credit report that where it can be tied to um, a, a survivor's status as a victim. So, two of the recent things that were added into VAWA, in addition to any of the instances of physical or emotional abuse, also what was added into there was financial abuse, or financial controlling behavior, and safety and technology were added in. And so if a survivor experienced financial abuse and they lost their housing because rent was no longer paid because the primary person in the unit was the paying the rent was the abuser, or their funding was misappropriated, stolen, controlled, or whatever by an abuser, and you can get any kind of statement or evidence to help support that survivor with that, that could help them to um, use VAWA to protect themselves in the admission process, which means that then the landlord would need to eliminate that from consideration. So if they had a report that we can tie back to an instance of that person being a victim, and you can demonstrate that those are linked, then a landlord has to reverse what I would call a denial at that point in time. So VAWA protects at admission. It also protects at maybe termination or eviction or things like that. So if the landlord is providing a survivor with a an eviction notice or a termination or something along those lines, and they cite reasons that things like too many police have been called to the unit too many times. Um, the victim can then invoke their rights under VAWA to have that dismissed from being a reason to evict them. Okay. And the form that they would need to do that. So the landlord gives the notice. The notice says you need to leave because the police have been called to your unit too many times. And then the victim's like, well, I called the police to my unit because I was being abused by by a perpetrator. So then the victim can then just say that to the landlord, and then the landlord can ask for documentation to support that, and that has to be provided within 14 days by the victim. And the form that the victim uses to provide that documentation is one of four things, and the victim chooses which they want to do, not the landlord. The victim can choose to use the form that I dropped in earlier in the chat, which is your VAWA self-cert. So that's form 5382. And the victim can use that. That can be the first thing that say, well, and you can share with them, hey, you can choose to do this. It's a pretty simple form. They fill it out, and the landlord can't ask for anything else on that unless there is conflicting evidence that's presented by someone else. So the self-cert form is one. The second way that they could actually provide information to demonstrate that they are invoking their VAWA rights is a third-party documentation. So that would be something like a police report that states, hey, the police were called out here and it was because there was an altercation happening between these two individuals, and this person is reporting this violence as a result of being a victim. It could be a statement from an attorney that's representing the victim. It could be a medical professional that is working with the victim. It could be a victim service provider who is working with the victim. That could be a caseworker, like people who are probably on this call. Um, or I think I said a medical professional. I might have said mental health. Either way, it's both. It could be a medical professional or a mental health provider that is working with those victims. And so they could choose that method. That usually has to be notarized. Sometimes some of that has to be notarized, the victim statement, the victim service provider statement, medical stuff, things like that. So that's a second way that they can provide documentation to invoke their right to VAWA. So one, self-cert; two, a third-party statement; three, they could use some sort of court or legal documentation like a protective order. So an EPO, an IPO, a DVO, all of those could be used, or any one of those, sorry. any kind of criminal court record, any kind of family court record. So anything that's coming through the court system that demonstrates that they are a victim could also be used. Um, but they cannot be required. So sometimes landlords will come back and say, let's just say the victim chooses to do a self-cert. They'll say, well, where's your EPO? Victims aren't required to file EPOs. They're not required to have DVOs or IPOs. So landlords cannot do that. Once the documentation has been provided, if it meets one of those four, and I'll talk about the fourth one in a second, one of those four categories, they can't ask for anything further. We usually see that that's what landlords want to do, and they're not allowed to do that under VAWA. So you just have to kind of point that out very gently. That unfortunately you don't have the right to ask for that. Um, and then we'll talk about, well, what to do when the landlord is insistent or won't drop it. Then that's where you file a complaint um, with HUD. And so, and fair housing can help too. And then the last thing that someone could use is any kind of emails, text messages, social media, anything that the victim has to demonstrate that they have been harassed or they are a victim of violence from the perpetrator. They can use that, but that is the one that is subject to more information by the landlord can ask for more information. So that's the only one that landlords could ask for more information about is that one, unless there's conflicting evidence that's provided again by someone else. So I talked about that a little bit before. So we accept the victim at their word. We accept the form that they choose to provide, unless there's a conflict from possibly someone else in the household. For example, the two people who are having the argument are in the same unit. And usually there's a primary victim. And sometimes when law enforcement comes, it's a little bit difficult to identify who that is sometimes. And so this is where VSPs coming in can sort of help, or victim service providers can come in and help, kind of help determine that. But that is the only time if both parties are trying to file a VAWA complaint. That's the only time the landlord can ask for additional information. And in those cases, sometimes the easiest and best thing to do is try to see if you can preserve the housing. Well, first, try to identify the primary victim. And if that seems a little bit impossible, perhaps work with the landlord. If it's your client that's one of them, work with your landlord to either bifurcate the lease or move your client would probably be an option to preserve the housing elsewhere without penalty. So that's one form, the 5382, the self-cert that's used as part of just generally a victim identifying themselves as a victim in order to invoke their VAWA rights, in order to be able to preserve housing that's being threatened by notices from landlords or things like that. I'm going to stop and see if there are questions. And
If
I
you
think
want to raise your hand, I'll unmute you.
well, that either means I'm doing really good or not. No, Laura. Okay. Are we ready to go? Thank you, Teresa. All right. So the next form I'm going to talk about, or the next process I'm going to talk about, is a request for an emergency transfer. The difference between a 5382, which is the self-cert form that a victim can use to invoke their VAWA rights or identify themselves as a victim for the purpose of either admission or to prevent eviction or termination. The difference between the 5382 and the 5383 is the 5383 is specific to a victim who's requesting an emergency transfer. Not all victims who are invoking a VAWA right with 5382 are trying to do an emergency transfer. That's a special process. And everyone who's running housing is supposed to have an emergency transfer plan, including our COCs. So I will say that at the national level, I've been part of a group that's been talking about emergency transfer plans. Some people are way ahead in that process. We all seem to agree that we have a procedure and that people are sort of doing it, but maybe it's not so much documented how to do it, or there's a designated person within the COC or a specific COC emergency transfer plan. And we will want to develop one for Louisville at some point, to put it down a little bit more fully on paper, because I believe everybody here that's doing this has come across it or is probably working with victims in an emergent situation to move them to a place of safety when their home becomes unsafe due to violence. So the 5383 is very specific for a survivor who is in housing, who wants to leave that housing. And that is literally what that means, an emergency transfer. So they want out of the unit that they're in and to a different space. It could be in the same complex, it could be with the same landlord, it could be completely different landlord, it could be across COC boundaries, it could be out of the state. So the emergency transfer plan needs to have a space to address all of those options for someone who finds themselves in a violent situation and needs to leave that. So the 5382 asks for a little bit more information from the survivor, specifically what size of unit they might be looking for, where is it they would like to be. So a little bit more details, whereas the self-cert is really just about, hey, I'm a victim and here's what's happened. But the 5380 to 83 is I'm a victim and I need to leave. And so that's that form. That one is also got to be honored in that same way. That form is very specific. There isn't the way that they can support the form is the same four things that we talked about with this, with the just, I want to declare myself as a victim. So the self-cert, the police report, something through the legal system, or if the landlord will accept it, the lesser things like emails, texts, and stuff like that. So they can still use those four things. It's their choice which of those to use to demonstrate support for the ETP. But the emergency transfer is a separate issue, separate form, and it requires that it try to be happening as quickly as possible. So victims typically you want to respond to that within 30 days. You want to get them moved as quickly as possible. If they do an ETP, usually what will happen is if there's a wait list at a property, and they're a victim, they're going to bump to the top of that list. The tricky part to this one is sometimes people want to leave and they want to leave fast, but we don't have places for them to go. And so that's the emergency transfer plan doesn't guarantee that. HUD doesn't guarantee that. You can't guarantee what isn't available. But it does say the option should be there to ask, and we should do what we can to honor the ask. So in a community like Louisville, where we do have more housing than many other parts of the state, hopefully we can find a safe place for that person to transfer to within that community if that's what they want. But we could also look outside that community if that's what they prefer, or if they haven't even thought about it, that could be a suggestion. Is there any other space that you would feel safe, that you would feel like would be a good place for you to start again? So the ETP is just a separate form, asks for a little bit more detail, and it's details about the kind of housing and the location and things that the victim wants to provide. And yes, Megan asks if I can email those. Laura, if I send those to you, would you be able to send them out to the
Yes.
group?
Yes.
Okay. So I will send Laura the docs, and then you will have the forms. Um, what about emergency transfers do you want to discuss? Yeah, the docs are going to go to everybody.
Yeah, she'll send them to me and I'll send them to everybody that's on the call. But Andrea, the question that I get the most is when we try to do an emergency transfer and the landlord drags their heels or wants documentation above and beyond to let the person out of the lease, um, how do you specifically navigate that? What things can we say to a landlord? What information can we provide? Is there documentation we can give to a landlord that says this is what you can do, this is what you can't do?
Yeah. So that VAWA form, that the one that outlines VAWA in general, the notice of occupancy rights, is a really great form to give to a landlord, and to have conversations with landlords about. It literally says to them, you can't do this. This is what the law says. Now, look, we want to preserve landlord relationships. So normally what I try to do with a landlord when we have this happen, and we do, we'll walk through it with the landlord. We'll say, okay, our person is invoking their VAWA rights. It's really critical for their safety that they want to do an emergency transfer. Here's what we can do to help facilitate that. So we automatically forfeit deposits. Um, there's no rights under VAWA that allows that deposit to be returned at all. It doesn't matter who paid it, whether victim paid it, you paid it, somebody else paid it, doesn't matter. Landlord gets to keep it. As part of our project in general, we offer double deposits right up front. So that means landlord's already got an extra security deposit on top of the original security deposit they would already have. If you didn't do a double at the lease up, you could offer the secondary if you had the funding and you wanted to sweeten the landlord pot. The landlord gets a 30-day notice from you. Our project, we do a 30-day notice. The victim doesn't have to stay 30 days, but we will give a 30-day notice to the landlord. So if it's the middle of the month, I'm going to go ahead and give them another month of rent. Now, under VAWA and emergency transfer, it's a little muddy with HUD, but the best direction I have got is that you can pay two separate landlords at the same time in an emergency transfer issue. So you would want a copy of that emergency transfer in your file and you would document what's happening. You're paying a current landlord to get out of a lease and you're paying a new landlord to get into a lease. So under that, it should qualify under the VAWA with HUD. Again, we always get a little bit of muddy information sometimes, but that's the direction that we've gotten from our experts that we're talking to about it. And I've asked that question very specifically because in the past we would always say, well, we can't pay two landlords for the same rental period for the same victim. Well, now under VAWA emergency transfer plan, we believe that the guidance says, oh, yes, you can. We also think that sometimes there's like a lease break. I don't want to really call it a lease break free because you can't pay the whole rest of the rental contract, but you could maybe say with the landlord, like I just said, we've got a 30-day thing. We can give you a 30-day notice and we will do that to kind of encourage landlords to work with us. If a landlord still refuses to let someone out of a lease who is invoking their VAWA right with the proper paperwork, and they're trying to request an emergency transfer for a documented safety issue, I'm gonna move them anyway. And then if the landlord tries to sue, I'm gonna bring fair housing or HUD or whoever I have to into that. We haven't, I say this and I should probably knock on wood somewhere. We haven't actually been sued, or our victims haven't been sued because our leases are between our landlords and our victims, and we have a contract with a payment contract with our landlord. But most of the time, we're trying to make a little bit of a win for everybody. One of the other things that we could do is if we have another victim that's in need of housing, we'll ask that landlord, hey, will you work with us on this person? You get this unit turned, we'll put this person in there, and then you'll have a person lined up and ready to go. So it's like there's not a loss of money there for a landlord. We've had that happen and done that before if you've got people looking for housing in similar areas. Um, and then I think I'm not remembering any very specific other things other than trying to preserve a landlord relationship, but also honoring the victim's right to leave an unsafe situation. And that's my priority. So I'm going to try and work with my landlord, but if they are not willing, I'm going to move them anyway. I'm going to move them anyway because the victim deserves safety, and it is the law. So then I'll get somebody else to help me enforce it if I need to. But that's where I come from. I I don't know if anybody else is as comfortable with that decision as I am, but I sleep really great at night, so I got no problem with it. Um, Questions? Would it help if we develop and I can do this, would it help if we develop maybe for the COC, maybe like a documentation decision tree of some
Oh, that
sort?
would be wonderful.
Okay. I think that could be helpful. One of the things I didn't mention, and this is just an aside about transfers and about VAWA self-certs, or that process in general as identifying as a victim, is that landlords, once a person identifies to a landlord that they are a victim, that landlord then is subject to VAWA confidentiality, which means they can't disclose the victim status to anyone else. They can't go investigate the victim status with neighbors and other folks. They can't share it with outside of anyone that's actually not working on that with that victim, like moving the victim out or things like that. So there are some confidentiality issues. I have literally seen that happen. I've had landlords go and then come back to me and say, "Well, I went and talked to the neighbors and they said that this or whatever." Doesn't matter what the neighbors said. The victim is saying that this is what's happened. And again, in the absence of a conflicting evidence from a person actually involved in the situation, you can't always go by and tell why it is you're talking about it. So it's really more important about landlords not presenting themselves as private investigators or police officers investigating an incident. That confidentiality right is important. I think that's good. And we could do the documentation decision tree about when to fill things out, and which one to use. We could also do that would be part of a larger plan, I think, but part of like an emergency transfer workflow kind of thing. Like what happens? What's the timeline? Um,
Both of those would be greatly welcomed, I think, with this particular group.
yeah. All right. I'm adding that to my massive to-do list. But I do think those are really important. The forms are already going out. Um, I think one of the forms that I did not include, but I don't believe it's necessary because it's really just HUD's model template for an emergency transfer plan. I think if you want an internal emergency transfer plan, you can pull down that document and you can use that as part of your protocol for your project. For us as VSPs, we just have a little blurb written. We don't even follow that big long process because we already do that because we are only working with victims of domestic violence, dating violence, sexual assault, and stalking. You all might not, that might not be your whole population. And so this again only applies to victims of dating violence, domestic violence, sexual assault, and stalking. Doesn't apply to anyone who doesn't fall under those IPV crimes. So again, the HUD rules are very specific to IPV. They're also specific to victims in the household. So if a person, it's not just the head of household that's protected, it's the persons in the household that might have been victimized as well. I'm not sure I mentioned that before. Okay, from Megan wants to move. Okay. So tips
All
on
right,
handling a
Megan,
situation.
you can unmute if you want to. Sorry to interrupt. Go ahead.
I was just going to read her question. It's good. But Megan, if you want to ask your question, I could answer it just from what you wrote in the chat.
Okay, go
Okay.
ahead and answer. Yeah.
Okay. So if someone is facing domestic violence and wants to move but doesn't want to claim VAWA, they don't have the right to move using VAWA. You have to invoke VAWA. So if they wanted to move but didn't want to invoke VAWA, then you can talk to the landlord and just say, "Hey, would you be willing to let this person out of their lease?" But they don't want to talk about VAWA. That's totally up to the landlord. Landlord's not subject to any kind of law whatsoever, and the victim is not entitled to any rights under the law if they're not going to invoke the law. Does that make sense? So what I would probably do is chat with the victim about their concerns about identifying, because if they want to invoke VAWA as a reason to leave, or that the reason that they want to leave is victim related, but they don't want to identify, VAWA offers them nothing. I mean, it's pretty cut and dried. So I would want to know and chat with them very carefully about, when I say very carefully, I just mean, from that perspective of, well, what's the concern? And can we alleviate or mediate the concern? And then talk about I would kind of run it through like a motivational interviewing perspective. What's the thing that could happen? What are you most concerned about? what's the best thing, what's the worst thing. I'm using some of those techniques, kind of trying to get a sense of what it is that's happened. It could be that they tried this in the past and it didn't work, or it came back because someone broke the law in some way and violated their confidentiality or something along those lines. But I would try to find out from the victim because you do have to be clear that you can't receive VAWA protections if you don't identify.
Megan, is the process re-traumatizing the person?
I'm honestly not very sure. We just had a client who, so with our policy, it is if someone claims VAWA, then we would move them, and then whoever if the perpetrator is in the household, we would
Yeah,
no longer serve that person.
right.
But since she's not wanting to claim VAWA, now we're paying as two separate households. Does that make sense?
So you're just bifurcating a program for those two individuals.
Right.
Okay. And that, first of all, I think that's a good, I think what you're doing is okay. Good, in fact, because you're at least honoring the desire to be exited from a household. Um, and I think as a program provider, you certainly can follow your policies, whatever those are, for situations like that, which sounds like what you did. You decided, okay, well, we're going to split the household. We got one over here and one over here. And assuming that you can absorb that in your grant, which sounds like you have, you sort of found a solution. But then my question to the person would be is if the reason that they wanted the bifurcation was to remove themselves from a situation where they no longer felt safe, then what are they going to do to try and keep themselves safe moving forward? Like, do they have any other safety concerns that you could help them address? Like, what is that continued relationship, if anything, going to look like? Are there shared children? So that would be the conversation. I would take it that direction with that person. But again, if you're not, if your policy allows you to do that and you did without invoking VAWA, you just went ahead and made the call, you're fine. Are you the landlord as well, or just you were able to get her off that apartment because you kept the unit with the other person? So you just modified a lease.
Right. We were just able to move her separately, basically.
Well, I respect you for honoring that. And I love that you did that with her without making her do that, and that you could do that in your program because you already had somebody else that was going to stay in the unit. Um, Obviously that solved your landlord problem because now it's just a lease mod. But if it were just her in a household and the perpetrator was not on the lease, okay, they might be living in the unit, but they weren't on the lease. In that instance, the person would need to invoke VAWA to get the landlord to follow VAWA, if that makes sense. I think it's two little bit of different things. And the landlord would not be obligated. Let's just say that, for example, your two people were not on the lease. One of them was, one of them wasn't, but was in the household, not on the lease, but maybe kind of unauthorized, if you will. In that case, if the unauthorized person is being left behind, landlord has no obligation to honor that, and the landlord can work to evict that person if that person remains. Um, and we sometimes will see this where a perpetrator comes into a unit. Sometimes they're invited in, sometimes they kind of force or coerce their way in. And we're always trying to chat that through with someone for safety issues when we see it happening, but the person's not asking to leave yet. Sometimes we will see that. Every situation is different. But certainly if perpetrators have been invited in for some reason and then refuse to leave, that's a whole separate issue. Do we try to work it through without invoking VAWA? It's up to the victim always. It's always up to the victim. You always just give the victim all the information they need to make a decision. But at that point, we would then work on that solution, which is a little bit of a different problem when the person is actually occupying the unit. We haven't talked about people who are the victim who aren't on the lease but want to invoke VAWA. They are still protected, even if they are not on the lease. So if they are not and they may not be the person in your program, but they have the right to establish eligibility. that is part of VAWA as well. If they are identified as the victim and there isn't any conflicting information, they have the right to establish eligibility for the help. The rules are clear under VAWA with that, and they have to be given time to establish eligibility. Usually it's up to about 90 days. And in some instances I've read with COC that you could give them till the end of a lease term, but again, it depends on the person and your program and what you're able to do there. But persons who are in the project who are victims who are not necessarily leaseholder are still protected. Okay, so Renee says when residents have not been in their unit a full year, but on a different grant, not a COC grant, because they have VAWA paperwork with the grant and or an application from another grant. Is that possible? Can you explain a little bit more? Can you come off mute and explain that a little bit more?
Yeah, Renee, you can talk. Just unmute yourself.
Looks like you're unmuted now. Now you're muted back. I guess I'm just a little unclear about, I don't feel like I understand the question really well. Let me try to break it down. Um, I saw you come off mute. Gotta love these technical difficulties. Okay, you're back on mute. All right. So if a resident doesn't have a full year contract, so they're under a lease for a year, um, is that and it's not a COC funded assistance that they're receiving. Is that a yes? Can you identify in the chat who is paying the rent? Like, what is the program that is paying the rent?
Renee, is this a Sheehan Landing person? Okay.
Let me try it another way. All
Yeah,
right.
we're not hearing you, so you'll need to
Uh,
put it in the chat.
okay. So scattered site.
Okay.
All right. So tenant based. Okay. If the funding source that is paying the rent is federal money, then it is subject to VAWA, regardless of where it is being spent. So if you've got scattered sites across Louisville and you are using a federally funded source to assist that unit, then that unit is subject to VAWA and that person in that unit is protected under VAWA because they're being federally subsidized. If they then identify as a victim, then VAWA must be honored. Does that help? Yes. Okay. Yay. Success. All right. Love it. Okay. Other comments, questions? Got good questions.
Yeah, raise your hand and I'll try to unmute you, or at least disable the mute so you can unmute yourself.
Well, in the meantime, I have that, excuse me, we're going to work on developing a decision tree and an emergency transfer kind of work through workflow kind of thing. And then Laura's going to send out the forms that we've talked about. Do you want me to include, Laura, that previous PowerPoint in case there's somebody on this call that wasn't on that previous
Sure.
call?
Yeah,
That's a heavy content.
yeah. And I'm
Uh,
going to put the into the chat the coalition's website, the training page,
uh-huh.
where they
Sure.
can access the recording of that as well.
Yeah.
And it is thundering and lightning like crazy behind me.
Oh no.
You can hear it
Wow.
on my microphone, but it is raining really heavy and there's thunder behind me.
Oh no. Well, I'm in Lexington and I got clear skies. Maybe cloudy, but no rainy. And it wouldn't matter if my internet wanted to go out. It could be as beautiful outside as it could be, and my internet would decide, I don't think I want to work today, and just decide to be spotty. But luckily, we're pretty fortunate with that today. Okay, so that PowerPoint that or that recording that Laura's going to refer everybody to is a basic I would call it like a VAWA introduction. It's as comprehensive as we can make it for about an hour and 15 minutes or so kind of training. The slides are real heavy content, and it's because it's trying to take over 200 pieces of legislative information and condense it down into about 30 PowerPoint slides. It's a training that's normally done that I've been doing for some, honestly, since VAWA was reauthorized with partners from the National Housing Law Project. And we would travel around the country kind of talking about VAWA and housing rights. And so we take it here in Kentucky and use it. We throw a little bit in there about Kentucky protections. There are some Kentucky protections for victims as well. They're very similar to VAWA in the sense that people can have emergency transfers 30 with a 30-day notice. They can have lease bifurcations, lock changes, things like that. But one of the things that Kentucky does require as part of its legislative effort for a landlord that's not subject to VAWA is a DVO. So remember I said under VAWA, landlords cannot require protective orders of any kind. They cannot require that someone produce that. But if you have a landlord that's not receiving federal funding and that property is not subject to federal funding, to VAWA rules, then Kentucky law could be helpful. But Kentucky law is going to require a DVO. So there is a little bit of a difference. And I hope I didn't muddy that up because this was very specifically VAWA focused. But I did want to let people know that there is a Kentucky option when VAWA isn't applicable. But as I mentioned at the very beginning, VAWA covers every federally funded program that's dealing with housing that's out there, including your program, if you're paying a landlord with your money and your money comes from a federal source. Um, so I hope that makes it as clear as I can make it and as clear as you need. So I don't want to keep anybody, Laura, if they got things to do. Um, so if we don't have any other questions,
Well, people have your email
they do.
and they know how to reach me.
They do.
So, yeah, if you'll send those uh, documents to me, then I can get that out to everybody that's on the call. And so reach out to Andrea if you think of a question later on or didn't feel comfortable talking about it in this venue. Um, Send her an email or send me an email and I can get it to her. I don't want you to feel like you're alone. VAWA can
Yeah.
feel overwhelming. And, if you're scared you're going to do something wrong or are not sure how to proceed, you've got resources. So just know that we're here to help you find the right people to make the right decision.
I totally echo that 100%. Um, please feel free to reach out. These are complex issues. These situations, they can be very concerning. They're I totally get it. So, I mean, I really do. I totally get it. There isn't anything that we probably haven't heard or seen or talked about or decisions that we all face. And we are all here in this kind of thing together. And everyone, one of the things I would like to end with is that everyone here probably knows someone, has working with someone, heard someone, knows someone, has a family member. Everybody, unfortunately, Kentucky has an incredibly high rate of domestic violence in our state, one of the highest in the country. And so it's highly likely that everybody here knows someone or has worked with someone. So if you have concerns or questions or just want to talk through something, we keep all of that confidential. You don't have to share any specific information with us, but just the story, if you want to chat something through, we're always open to anything that can help make a situation safer for a victim or make a program feel more confident in the decision that they're making with regard to serving victims. So thank you. Thank you for all that you do for everybody, but especially because I work with victims on behalf of victims. So thank you very much. Just reach out if we can do anything for you and have a wonderful rest of your day.
Thanks, Andrea.
All right.
And if you get a prompt for a survey, please fill that out and let me know about your experience for today. Thanks.
Thanks, everybody. Bye.